haven't identified any anti-competitive act. And by your statement, I suspect you agree with that. And that is because you're saying that hypothetically they could change the rate, but in fact, they haven't changed the rate. So is the anti-competitive act that they won't let someone else on? Is that what you're arguing? Or what is the act that he says that Epic's not identified?
Yes, in the app distribution market, the anti-competitive acts, plural, are the technical restrictions that are imposed and the contractual restrictions that are imposed that prevent alternative distribution from being available on iOS. It's that simple. Epic right now today would like to have its own store to distribute apps on iOS. It can't because Apple has prohibited it. Flat forbid. That is the anti-competitive act at issue.
The courts have sometimes indicated that licensing restrictions, which is what those are do not constitute antitrust actions. And there seems to be great disagreement with the licensing provisions at issue here. What's your response?
I would say, Your Honor, there is no blanket exclusion to the antitrust laws for licensing. There are a variety of cases that analyze the use of patents, for example, and whether or not they are misused or whether in a way that is in violation of the antitrust laws. There are situations in which
when that happens, aren't they coupled with some other act?
And here, Your Honor, I would say they are. I'm not sure, frankly, that is a requirement, but here I think it is the case.
Well, do you have law to support that notion? Because there is law to support the notion that disputes over licensing is insufficient.
Your Honor, I think in terms of whether or not the court is suggesting that a dispute over licensing is per se exempt from the antitrust law, I would submit that is not correct. There is, if that were the case, for example, the Ninth Circuit's decision in Qualcomm recently would have come out, it would have been much easier to write for the court since the issue there turned on patent licensing. There was instead an in-depth analysis of the nature of the restraints and the effects. And the court did not simply excuse the conduct at issue from antitrust scrutiny because it related to licensing. There is also Federal Circuit case law on the subject, and I am temporarily blanking on the name of the case because I hadn't considered the issue since it wasn't raised in Apple's brief that licensing was somehow excused completely from the antitrust laws. We can certainly submit supplemental authority if that would be useful for Your Honor.
No, it's just a question I had as I was reading the cases. Mr. Dorn, any comment?
Just a couple, Your Honor. First of all, in our opposition, we do in fact, of course, speak to a party's right to safeguard its intellectual property. And we agree with Your Honor's observation that that is not an antitrust violation. I would also note, Your Honor, that counsel for Epic acknowledged that what Epic wants to do here is open its own store within the App Store. That's really what this litigation is about. That's really its objective here. And that takes us back to Apple's fundamental business model. And frankly, the contention by Epic, which it repeats, but never proves, that Epic's commitment to safety, security, and the privacy of its user information is a pretext. And that is essentially an indictment of Apple's entire business model, which has been committed to the safety, security, and privacy of its users since day one. And it also ignores the record in this matter, such as at Schmalensee paragraph 36, he notes that less than 1% of malware attacks occur within the App Store. And that is because, Your Honor, Apple safeguards the App Store and safeguards the iOS operating system to assure that its users are safe and secure when they come into this environment. Now, Epic would like Apple to let it into the App Store. and would like to let Epic set up a competing store within Apple's own store. That is a fundamental disagreement with the way Apple has chosen to do business. But Apple's business model has been consistent throughout its existence. This is the way it has chosen to set up its model, and its trademark is to safeguard its users. And it has concluded that through app review and through maintaining a system where it closely controls what is on iOS, that is the best way to safeguard its users, and that's what keeps it competitive in a very competitive marketplace. And the statistics bear out that Apple's efforts have been effective. Secondly, Your Honor, counsel commented that the court should look at the 63% figure rather than the 10% figure. Your Honor, I would suggest that Fortnite has the data, and they could have put forward very precise information for this court had they so chosen. The 63% figure states that 63% of Fortnite users on iOS access Fortnite only on iOS. That does not tell us how many actively play. That just tells us that if we look at everyone who has ever opened Fortnite on an iOS platform, that they didn't use others. Perhaps they looked and lost interest. We don't know. There's no information offered. The one relevant comparative statistic, the one that tells us how Apple compares to its competition in the marketplace, is in the line before that, which states that from the time Fortnite was launched on iOS through August 13, 2020, nearly, so less than 10% of Fortnite's average daily players used an iOS platform. There is huge market competition. The market is broad, and Apple does its best to compete. But we know, and Mr. Schmid's declaration is the one piece of evidence in this case regarding the market discipline or specific testimony. And Mr. Schmid testified at paragraphs 8 and 18 in his declaration that he has been repeatedly told by Epic that Apple is the smallest piece of the pie, and that Apple has to hit Epic's deadlines or they'll proceed without them. No one in any of the Epic declarations has denied that. They too have said, we have told them they need to hit the mark or we would leave them behind and only bring them in later.
I think that that's what the numbers bear out, right? Fortnite, where Epic has advised the court, what they've got 350 million users, 116 million have registered their device, so somehow linked in iOS. 10% of their 25 million daily users.
2.5 million, Your Honor. Oh, I'm sorry, I apologize, Your Honor. 10% of the 25, understood.
Right, 10% of the 25, which gives you about 2.5 million. Of that 2.5 million, maybe, I guess, 63% only linked to their iDevice. So 10% of 63 is about 6%.
I'd agree that that's a reasonable alternative reading of this paragraph. Yes, Your Honor. About 6% of
now, 6% is still about 1.575 million people, not an insignificant number.
And Your Honor, as
devices, I would say, right? 6% is small for Epic, but it's still 1.575 million people.
And yet, Your Honor, it's remember, we define the market looking at the product, not the consumer. And the product here are channels of distribution for Fortnite. And what this tells us is, and what the court has already noted, is there are many channels of distribution for Fortnite. And even if Your Honor's interpretation that you just offered is correct, and as I said, I think it's a reasonable interpretation of what's written here, nonetheless, that does not mean that these users, should they want it, can't access Fortnite through other channels. But again, for purposes of this antitrust analysis, the question is whether or not Fortnite has alternative channels. And additionally, under the antitrust laws, Fortnite is not entitled to necessarily access to every single person on the globe. They only need to have reasonable distribution alternatives available, and they have that in spades.
Okay.
Your Honor, if I may address the numbers here.
Sure.
Thank you. I note that Mr. Doran did not endorse that particular interpretation of the numbers and said, well, it's a reasonable reading. I submit that's because he probably understands that's not actually the right number here. The 63% is 63% of the 116 million people who have downloaded Fortnite onto a device or have otherwise logged into Fortnite. So we're talking about 71 million people or thereabouts based on my rough math, not 1.75 million or whatever 63% of 2.5 million is.
I wasn't saying the